Hello again, this is Grant Swartzwelder, and welcome to another episode of Oilfield Strong. Today we're going to talk about a topic that the oil industry really kind of doesn't like. It's called the Endangered Species Act. It's been used to really thwart activity in the oil industry, or that's the perception. But today we have a speaker that is going to has not only the qualifications, but I think the temperament to talk about this in a way that I think could be enlightening for the industry. I've known her quite some time. Melinda Taylor, we've worked on different things together. I've known you personally. But then when I did research on here, I've discovered that you're really actually very important and very knowledgeable. And so much so, it could be my dementia, or it could be that you just have so many things that you've done that I actually have to read. Normally I can memorize this, but you're a distinguished senior lecturer at the University of Texas Law School. You founded the K. Bailey Hutchinson Energy Law and Business Center. But there's a lot of things before that I think really bring this topic into clear focus. Director of Ecosystem Restoration Program at EDF. So you've seen it from an environmental advocacy standpoint. Deputy General Counsel at National Audubon Society. You're teaching classes in a whole variety of things related to ESA. And so so I think you're a perfect person also because of working with you. I've seen that you're, moderate or at least just rational in how you think about things. And that's something that, I don't know if you know this, but that's missing in this world today. So I think that would be very, very helpful. So with that, though, I'd love to just start off with welcome, but tell us kind of the history of the Endangered Species Act. I have heard there's folks out there that tell me that ESA actually stands for Everything Stops Always. I don't know if that's the case or not. Yeah. Then the other question I have is that I have heard, as a good Aggie, I have heard that the Longhorn football team is going to be put onto the Endangered Species Act. Is that true also? So there are a lot of misconceptions potentially in this ESA that is why you're here. So take any of that and run with it.
All right. Well, first of all, thank you, Grant, very much for having me today. I very much appreciate it.
Hopefully that's the case after this. We'll right, see. We start strong and then we'll see where we end.
That's fine. I know you well and I totally trust the process. So have to start with the Longhorn dig and push back a bit. I think, we'll see what they look like tomorrow against Vanderbilt, but I am still very optimistic about the season. Not as optimistic as I was a few months ago, but still very optimistic. So, So a little bit about the Endangered Species Act. I, as you mentioned, have worked on issues related to the Endangered Species Act my entire career. So that's well over 30 years at this point. And one of the things I hope we talk about is how I think the ESA, unfortunately, like a number of other environmental issues, has become a very polarizing issue.
Definitely.
It's one that people in the industry have difficulty at this point finding common ground with people in the environmental community. Landowners, of course, also have very strong opinions quite often about the ESA. And starting with the history of it, that was not always the case. So the ESA was passed by Congress in 1973 during the administration of Richard Nixon, of all people.
It is amazing when you think that a Republican actually did that.
Yeah.
But, it's a different world these days.
Totally different world. The vote in the Senate was 98-0.
Wow.
So there was literally no opposition in the Senate, or at least the two senators that might have opposed it weren't in the chamber that day. So it passed with a lot of bipartisan support and enthusiasm. It was also part of a wave of environmental statutes that passed in the late 60s and 70s. And it was a different time, as you say, but there was a lot of concern at that point across the United States, again, across political parties, about what people back then were observing about the environment, dirty water, dirty air, and the dramatic loss of species. So anyway, so that's where it started. It, of course, has evolved over time. I think as people across America sort of saw how strong the prohibition on harming endangered species really is pursuant to that act, then we started to see more opposition to it. But it is good to sort of always start with the fact that this was a bipartisan initiative. And there was a lot of strong support, from people all over the place for protecting wildlife.
So take that and say, you kind of talked about what the purpose is, but go a little deeper in that. It's plants, it's wildlife, it's meant to take care of endangered through habitat.
Right.
Kind of go into that detail of what it's originally supposed to be doing.
Right. So it's supposed to be protecting animals and plants from extinction, basically preventing extinction. And the first few sections of the Act talk about protecting ecosystems. So, the whole system out there that supports these plants and animals. Congress clearly recognized that economic activity and development was causing the decline of these species. So it's not the only cause. There are certain animals, obviously, that have been overhunted, for example, though that's less and less of a problem these days. But at the time, that was a problem. Some animals and plants suffer from disease or from not being able to compete with species that are introduced to their habitats. But from the very beginning, there was this recognition that certain types of land development activities and commercial activities did cause harm to these species. So that's what the Act was enacted to prevent.
And we're talking federal, but there's kind of a state equivalent within the state of Texas also through the Forest Service. Or
Parks and Wildlife Department. Yeah, there is a state equivalent. It's not as strong, let's put it that way, as the federal statute is.
Now, is that because of desire or because of regulatory capabilities?
Well, it's the way it's drafted. It doesn't give, for example, one of the things that a lot of people on the industry side of these issues find alarming, and maybe on the environmental side applaud, is the fact that third parties, environmental organizations, can sue someone who is violating the Endangered Species Act. And that is not the case under state law. So there's some differences like that.
And so when oil company, and again, since this is Oilfield Strong, I'll take it from a perspective of an oil production oil company, do they need to worry about the state side? It's really the federal side. I say worry is probably a bad word, but it's a federal that's really the main driver of this.
That's right.
Okay.
Yeah.
Well, I just want to clarify that.
Yeah.
So let's talk about some of these misconceptions or not. We talk about where the genesis and then kind of how it's evolved. And it seems like a lot of that is when it became weaponized. And it seems like the ESA has, from a litigious standpoint, from a kind of different permitting requirements standing in the way, that has really pushed it to be a tool that has helped environmentalists in ways, but is probably why it's a bane of the existence of oil and gas.
Right. Well, one aspect of the Endangered Species Act that one notices as soon as you start reading the Act and looking at how it's being implemented is there's an on-off switch. So before a species, whether it's a plant or an animal, has been actually listed or identified by the federal government as being endangered, or there's another category called threatened, there are no protections that apply to that animal or plant, regardless of what scientists might be saying about how rare that animal is or plant is. But the moment the federal government lists that species, and that's done through a formal administrative process or rulemaking process, then all of these protections that the Act contains become effective. So all of a sudden, a landowner, whether it's an oil and gas company with a lease or a rancher in North Texas or Colorado or wherever, once an animal exists on their property that yesterday was not listed as endangered, but today is, all of a sudden they are facing a bunch of prohibitions. Well, the main one being they can't do anything that would harm that species. So I think, in terms of going back to your question, weaponizing it, that sort of debate about the restrictions and what should landowners be allowed to do or not do or whatever begins with that listing process. And we're seeing that with the oil and gas industry. understand that very well, and they have put a lot of effort into opposing that initial listing process. Now, I'm sure we'll talk about it, but I would argue that the listing shouldn't be a political decision like that. I understand why it is, but the act
And it is
actually,
because it's the start of the process
that's
that
right,
could end up.
because it flips that switch,
Okay,
right?
fair enough.
But the reality is that once a critter is on the list, the Fish and Wildlife Service, which is the federal agency that manages these matters, actually has a lot of flexibility with respect to, how rigorously they enforce that prohibition on harm, what types of activities get a permit from them, which essentially enables the oil company or whomever to continue operating, but under certain conditions. So there are ways to inject more flexibility into the management decisions that I think at least what I'm observing from the oil and gas industry right now is we don't even want to get to that point. Let's do all we can to prevent these animals from going on the list. So
several things there to unpack. First, listing.
Yeah.
When I see how some of that's done, like if you have a lizard, how do you know where its habitat is? How many lizards are there? How do you count that? And so it seems like it creates a lot of room for either side to say BS to this, or
right.
or for sure this. Are we doing that the right way to even know what our issue it really is for a given species?
I think for the most part, yes. I
think it's more just people being suspect of government or environmental advocates.
I do. I mean, and that's not to say the science is perfect, because it's definitely not perfect. But before a species ends up on that list, where the switch is flipped, there is a lot of rigorous analysis by the governmental agency that goes into that to evaluate, how strong is the science that would support the fact or this hypothesis that this lizard needs to be on the list. Are there gaps in our knowledge? Do we, and the agency does make decisions fairly often not to put something on the list, either because there's not sufficient information or there are just higher priorities out there for the agency to try to protect, and they can't protect everything. So I do trust the science behind it, but I also understand that perception that, wow, nobody's ever seen a dune sagebrush lizard, or very few people have. So how do we know? And why are we being told that we've got to avoid these areas and so forth? So I get it.
And not to be the Mr. Negative figure, you also look and say, why is it really that important if this lizard goes away?
Right. Well, and that's, the ESA doesn't ask that question, right? Congress back in 1973 made the decision that it was in the national interest to protect biodiversity, full stop. So we could amend the act, and Congress from time to time considers doing that, and put sort of guardrails around, if you will, the species that would be eligible to end up on the list. But we haven't done that yet.
Its own set of issues.
Of course,
there.
right.
All right, so you talk flexibility. Let's talk about that, because you do have examples of oil companies really trying to help on habitat, and then you have environmental advocacy groups really trying to work. But how can groups work together to save species or just make habitat more likely to be a great place for these species to exist?
Yeah, I think there's a lot of options on that, actually, and models that have been tried out. I mean, here in Central Texas and Travis County, there's a very good model. It's a big regional plan called the Balcones Canyonland Conservation Plan that was put together back in the 90s to protect habitat for 2 songbirds that were listed as endangered. It also protects a bunch of little cave species that occur in these karst limestone formations that are under the Balcones area. And that was a huge effort. It involved local governments, environmental organizations, land developers, the whole kit and caboodle. But those stakeholders got together and figured out, okay, where's the most important habitat to protect? We'll all agree that should be protected. But the trade-off was that development can proceed outside of those preserved areas with really no restrictions. So that type of thing gives you some flexibility. There are also something called conservation banks, which I understand there's actually some talk of establishing one in the Permian Basin for dune sagebrush lizards. So the idea there would be that a company, maybe a sand mining company that is operating in an area that has habitat for the dune sagebrush lizard, could buy credits from this conservation bank, and that would be all they'd need to do. They would continue operating in their sand mine in compliance with the ESA.
But does that really help if you're really trying to save the lizard? Just buying a credit doesn't save the lizard. It's more of an administrative.
But the credit is used to protect habitat for the lizard within the range of the lizard, within the same general area, but on a different tract of land. So the idea is you're sort of trading off. You're saying we can develop this part of habitat for the lizard, but we're going to protect this big area over here. And by doing that, we're going to make sure the lizard doesn't go extinct.
Okay.
So, yeah.
The other thing that I've noticed within the ESA and environmental advocacy as a whole is it changes every 4 years.
Oh, yeah.
And I'm talking obviously about the presidential election and the administration. And so a couple of questions out of this. You have with the kind of environmental advocacy maybe on the rocks or having a little more challenge, how does the ESA fit into that? In one way, I could see that being weaponized even more as a tool, or what?
Yeah, I think this is something that actually gives me a lot of heartache, frankly, because when I started doing environmental advocacy work 30 some odd years ago, I lived in Washington, D.C., did a lot of work on the Hill, and I would literally go and talk to Republican members of Congress or Democratic members of Congress, Republican senators, Democratic senators, about particular issues. And I was working for an environmental group, national.
Particular issues of the
environment.
or
species, yep.
Or
species and water and lots of other environmental issues. And you would have a conversation with a member based on what his or her constituents might find appealing, right? Like you're talking about the substance of a bill you're supporting or a bill you're opposing or whatever. But it was not done according to party lines. Unfortunately, today, and particularly over the last 3 presidential administrations, we've seen these wild pendulum swings back and forth, with the Obama administration being very aggressive in passing and implementing regulations on species and other environmental issues, and then a big swing back during the first Trump term, and then a big swing back again during the Biden administration. And then now we're seeing that during the Trump administration to go kind of, swing back the other way. And clearly that has lots of negative repercussions. I mean, landowners, oil companies, and others there's a lack of certainty about what the long-term requirements are going to be that apply to them. It's certainly bad for species in terms of endangered species, because you'll have, for 4 years, those species might be enjoying a lot of protection. And then, boom, the pendulum swings back in their efforts to roll back the regulations that just became effective 4 years ago. So, so we're seeing a lot of that right now. And the Trump administration this time around has been not shy about proposing regulations that will dramatically change the Endangered Species Act, the way it's implemented, not the act itself, but the regulations. So
chances are the next 3 years will be more of that same.
One would assume so.
So how does environmentalists, environmental advocacy folks address that?
Well, the kind of at the basic level, they will be litigating and opposing these.
So almost being forced to use it as a weaponized.
Exactly. And one regulation in particular, the administration is proposing rescinding the definition of harm, which sounds very in the weeds, and in a way it is, but
that's a driving force.
It's a driving force, and it's the basis on which the Fish and Wildlife Service, the federal agency, exerts jurisdiction over habitat for species. So, that would be a dramatic change, clearly, if that definition goes away. But the environmental community will fight that through litigation and may or may not prevail. Over the long run, I think it's important for the environmental community and the regulated community, frankly, to start thinking about big picture. How do we fix this going forward? Is this the right framework? I'll go back to this issue of the switch goes on for all of these prohibitions the minute that a species is listed. Well, maybe that shouldn't be the case. Maybe a subset of those restrictions goes into place, or maybe the listing of a species triggers another process where the affected landowners and members of the public get to come in and talk about what's reasonable in terms of habitat protections. You know what I mean? But we're a long way from that.
And it's a fine line because you have to have some enforcement because chances are oil companies, private landowners, they probably don't want to spend that money. They don't want to have those requirements. So how do you balance that without going too far?
Exactly.
Well, you talk about private landowners. How does this square with the whole idea? Texas obviously is very into private ownership, the independence associated with that. Well, this puts a kind of a cover on that to some degree.
Right. Well, it's a difficult issue, especially in a primarily private land state like Texas. But again, I kind of go to the facts. The reality is that 2/3 of listed endangered species rely on private lands for at least part of their life cycle.
Sure.
So, any discussion of, well, the act just shouldn't apply to private lands, that would mean we're going to have an act that's a whole lot less expansive and protective, right? And we're just going to sort of, well, at least from a federal protection standpoint, write off those that occur on private land. So that can't really be the answer. So that, it's unclear. I mean, I also think Texas, we have a lot of biodiversity in Texas. We have 90 some odd listed endangered species. But the vast majority of private landowners are not affected by endangered species. It just so happens, particularly with a couple that occur in the oil patch, that
I didn't know that a lesser prairie chicken existed. I didn't know about this sagebrush lizard existed, and I believe they're out there. I don't know what they are, but they've become famous.
Yeah, they have. And the lesser prairie chicken is quite hard to find in Texas. It does occur in New Mexico and the eastern part of the Permian.
And for example, that's a case where aren't they pretty prolific up in like Kansas or Nebraska up there?
Well,
so it's like, well, y'all just move your families up there and you're all fine.
Right, exactly.
So how do you balance that?
There. Yeah. Right. Yeah, the prairie chicken's an interesting case because it historically occurred across 5 states in the Southern Plains. So it's New Mexico, Texas, Oklahoma, Colorado, and Kansas. And there are still remnant populations in the southern part of that range, but the majority of the population is more to the north, especially in Kansas, but also Colorado. But the Fish and Wildlife Service they just lost a big lawsuit about listing that species, but they are spending a lot of time and effort trying to figure out how to protect or conserve the remnants of these populations that are further south. And they're, up in the panhandle of Texas, they're not as rare as they are in the Permian Basin in West Texas.
So there's certain parts of the oil industry that would be affected, and this kind of goes back to what you were saying that it sounds like the ESA is kind of blind to what animal and whether they should exist, but should all of these endangered species, I guess there's no difference between them. They're all kind of, in theory, treated the same,
right?
Even though some live in Kansas and some don't.
Right. And there's, again, some details in the weeds about prairie chickens. There's some genetic differences in the population that's to the north and to the south. But from a legal perspective, they're all treated the same.
And it kind of goes back to the perception that if you have the chicken up there and it's doing fine, but you pick on the oil industry, we'll put in quotes, then are you hurting yourself or the environmental advocacy folks pushing that chicken? Is that hurting the overall movement because it looks like we're kind of, the environmental advocacy folks are picking on the oil industry and using it as a tool when it's, you see where I'm heading with this? Obviously not that well said, so save me here. So it's
No, well, I'll take issue with picking on the oil and gas industry.
Possibly a harsh word, but I am
right.
in the oil industry. So.
I mean, sure. And the oil industry is not alone, right? There are species whose habitat overlaps with, interferes with, et cetera, lots of different extractive industries. I mean, a lot of the controversy over the Endangered Species Act during the 1990s, for example, was really around the timber industry, Pacific Northwest and Southeast. So the spotted owl, which everybody remembers, even if you don't remember the details of those battles.
I've heard of the spotted. He was famous before the chicken.
That's right. And the red-cockaded woodpecker, slightly less famous.
Yeah, not as.
Also very controversial.
Needed a better publicist.
Right, for in the Southeast United States. And the timber industry they went to war over the listings of those two species for the same reasons that the oil industry is concerned about the lizard and the lesser prairie chicken, that they really felt like listing those birds would shut down their industry or dramatically curtail it. In the case of the northern spotted owl, I think they were right to some extent. I mean, there were other factors.
I'm sorry, who was right about what?
The timber industry was right that
it would have an impact on
that it had an impact on their industry. And because once that bird was listed, the government said you can't harvest timber within these large sort of circles. They drew circles around the trees where the spotted owls were nesting. And those circles were pretty big, and that meant that a lot of the national forest up there was off limits to timber harvesting. Now, there were other factors that contributed to the decline of the timber industry up there, so I'm not here to say it was only a spotted owl, but I do think I get it. I understand why that industry was very much opposed to that listing. Now, the environmentalist would argue, yes, but the spotted owl was on the brink of extinction, and that's what the ESA is designed to prevent, right? And it did prevent extinction. Again, there's some other threats that the owl faces today, but It did prevent extinction. And maybe even more important, the spotted owl was sort of considered an indicator species for the health of that entire kind of old growth forest ecosystem, right? So, again, kind of going back to your question, the oil and gas industry, I don't think is being picked on. It just so happens that these two species, their habitat overlaps with this very important industry in our state. It also, and oil and gas is not alone, because the wind and solar people don't like the listings either. So, that's the way it's come down. But I don't think I can say with a lot of confidence that I know this firsthand because I've talked to them, the people that initiated the listing process for both the lizard and the prairie chicken. And by the way, that can be done by an environmental organization, not always just by the government. The organizations that spearheaded that, they were not thinking, well, they knew where the critters were, but this was not about shutting down the oil industry in West Texas. This was about protecting those species that are being impacted by oil and gas activities.
So, but obviously the perception would be that
I get it. Yeah.
So it's
but
that
see,
makes the challenge.
Yeah, but I think that is an unfortunate. That's evidence of where we started with this conversation, right? That this whole discussion has become so polarized and so politicized because really, I mean, of course, does the environmental community like the oil and gas industry? I'm
guessing no.
Yeah, I mean,
just a guess.
Although many of those groups do work with the oil and gas industry, so it's not an entirely contentious thing, but they weren't motivated by trying to hurt the industry. Do you see the difference? But yet I understand from the industry's perspective, it feels like that because So
put your, mind around this one too. How do you convince oil companies, private landowners to be more open to this and to work with? What are the solutions or the motivations that you can go to?
Yeah. So during the way back in the Clinton administration, the 1990s, when Bruce Babbitt, former governor of Arizona, he was Secretary of the Interior. He was a Westerner, of course, and he was very familiar with the problems, if you will, of the Endangered Species Act, especially when it comes to protecting species that are on private lands, or whether it's oil and gas, development, developers,
Sure.
whatever. So when he was secretary, the Fish and Wildlife Service came up with a whole suite of different programs that were designed to make it easier for private landowners to comply with the act, give them incentives to participate in programs that would conserve habitat, expanded the use of both financial incentives and regulatory incentives to do that. And they saw some real success in terms of having more people apply for Section 10 permits, which just as a way of saying more people actually complying with the act and going through the regulatory process, getting some agreement even before species were listed about activities that would continue to be kind of allowed without a lot of oversight and regulation, and other things that would require some oversight. So there was a lot of success in the 90s. I think, again, one of the things that I've been thinking a lot about is, have those programs not run their course, because they need to persist, but they're not sort of staving off opposition to the act from people
But
like the
you see
industry.
those as actually, you said the 90s, but do they still?
They still exist.
Mm-hmm. But and maybe I'm just not in that world, but I don't hear about them. Are they real? They exist, but are they just a shadow of what they used to be, and no one really cares?
They're pretty significant.
Okay.
But yeah, and with respect to the lesser prairie chicken, for example, there is something called a candidate conservation agreement with assurances that was set up in 2013, 2014, before the prairie chicken was listed the first time. And basically, it was set up so that an oil company could pay an amount of money, and the fee was based on how many acres of development the company was going to do in prairie chicken habitat. And once they paid their money, they were authorized so that if the species became listed, because this was all done right before it was listed the first time, they would not be subject to any further restrictions. Okay. That's an example of one of these regulatory incentive programs, and there's quite a bit of participation in that program for prairie chickens.
Okay.
So again, I think in the 90s, the existence of a program like that would have translated to maybe less opposition to the ultimate listing of the species. Now, we didn't see that. We saw the oil and gas industry, despite the existence of this program that Fish and Wildlife Service had said, hey, let's set this up so it's really easy for all of you oil and gas drillers to participate, and you're not going to be burdened with a lot of paperwork once the bird's listed, et cetera, et cetera. They still fought the listing. The industry has decided they don't want the species to be listed.
They're trained to immediately.
That's right.
And that's a tough thing to overcome,
It's a very tough thing to overcome. That's right. The lizard situation's a little different, but in that case, the Obama administration decided not to list the lizard because of something that Susan Combs had helped spearhead, the Texas Conservation Program. That was a state-led effort that oil and gas companies paid into, and the idea was that should be enough to conserve the lizard without the need for a federal layer of protection.
So do you think the oil companies will finance those type of things and do those things if the fear of the litigation and the boogeyman of the listing wasn't there?
I don't think they would, no. In fact, what we saw, again, going back to the prairie chicken, when the bird was delisted, so we set up this program. We didn't, but the Fish and Wildlife Service set up this CCAA, it was called. We had a lot of participation, but the oil industry still fought the listing, and they ultimately prevailed. So the court in the federal court in Midland, Western District, directed the service to vacate that listing. As soon as that listing was vacated in 2015, the participation in those programs just cratered. I mean, there were not any new. Now, the people that had signed up were still protected from a regulatory standpoint, but there was no new sign up. Yeah. So again, that's tricky, right? How do we get over that?
And that's why I have you here. You're supposed to have these magical answers
right.
on how to get companies who are geared toward, economics and earnings to worry about these things.
Yeah. And I think it's tricky. I'll say this is anecdotal, but I was talking with somebody this week who does a lot of consulting with the pipeline sector, pipeline companies. And this person commented to me that the culture, sort of corporate culture, at least of a significant part of that industry, seems to be a bit different than some of the oil and gas drillers. Maybe that's because they've got deeper pockets. I'm not sure. But anyway, with respect to the lizard, for example, they seem to be taking a lot of steps to try to, let's make sure we're avoiding lizard habitat, that there's no question later that we might have impacted lizard habitat. Yeah, that's just, again, anecdotal.
That's interesting, because I would have thought with Energy Transfer winning that big suit against kind of that, and I'm mixing kind of some examples, but it seems like they might be more empowered to fight against anyone that's pushing environmental regulation.
Yeah, and again, I don't want to overgeneralize, but it was interesting to me. I mean, this person basically said they want certainty more than anything else. So if there is a program available to them, like the prairie chicken program that I told you about, or a conservation bank, which some other people are trying to establish for the lizard, and they can just write a check and be done with the mitigation that's required of them,
and let someone else take care of that. So
that's right.
Very good.
So,
Melinda, any final thoughts on various misconceptions that need to be thought through, or anything else?
Yeah, I mean, I do think the biggest one is this, the idea that the act is completely inflexible, because it's not. Even if somebody wants to drill a well and write in lizard habitat, the federal government is not going to come in and tell you can't do that, but they are going to come in and say, in order to do that, you need to get a permit from us, and that's going to require protecting some habitat for this critter somewhere else, not on your site, but someplace else. So, it's not shutting down drilling in the Permian or anywhere else. Is it creating some red tape for people? Absolutely. And I'll say that all day long, but the Endangered Species Act really does not stop projects, much to the chagrin of a lot of environmental organizations. They wish it did.
Sure.
But, yeah.
Melinda, thank you very much for participating. Having that moderate viewpoint and being more of a problem solver than a problem creator. I think this world could use a lot more of that. And here at Oilfield Strong, I think having these viewpoints and understanding how environmental advocacy groups look at things, I think can only make the industry stronger. And it might help us understand that maybe there are some good things that we could do that might not necessarily affect the economics of our operation, but might be good for our communities and kind of the license to operate. So with that, thank you very much for participating and viewing this episode. Always look for us on YouTube and various podcast mediums, and thank you for participating.